reason I have these in green, but I don't have 5 and 6 under federal in green, is because those 4 primary sources of law that I have in green are really the ones that come in authority level. The bottom 2 are more like wild cards. So let's now talk about number 5. Under federal court decisions. This is also true under number 5 in state. And this is judicial court decisions. Sometimes we refer to this as common law. Judge-made law is another way of saying it. Sometimes it's called precedence. It goes by various different terms, depending. And what we're talking about now are court decisions. So I want to first start with this phrase, common law. All right? You'll hear this term all the time. And there are 2 meanings to common law that I want you to be aware of. The term common law. The first, let me blow that up so you can see my, and I apologize for my handwriting. Never had very good handwriting. All right. So first, when we talk about the term common law, historically speaking, this goes back to the law of England, English common law, that carried over to the colonies here in the United States. So back before the United States ever existed, we had various colonies, and in those colonies, English common law was applied. That was the law that was applied in the courts, etc. And that was derived from the law of England, which was brought over to the United States, well, what would become the United States post-revolution. So when we talk about common law, let's talk about the United States. Okay, we have Revolutionary War, United States, we have Declaration of Independence, we have the formation of the U.S. Constitution, and so we have little baby United States, late 1700s, right? The United States is just a little tiny baby, still in diapers, brand new country. We did not have a lot of law at that time. We're talking like the 1790s, okay? So we had the U.S. Constitution, a smattering of statutes, not a lot. And so we didn't have really a lot of law. So for example, back then, let's say you're my neighbor and you borrowed my milk cow so you could make milk and butter. And I said, okay, well, bring my cow back in like 2 weeks after you're done. So you never bring my cow back. So I sue you, remember we're in little baby United States, early days. I sue you in a United States court. I'm asking a judge to order you to return my cow or to pay me the value of the cow so I can go buy an heirloom. So I have to apply law in court. So if I look in the Constitution of the United States for the laws involving cattle, cows, bovines, there's nothing in the Constitution about cows. So I have to apply the law from somewhere. So what does a judge do? The law would say, okay, or the judge would look at U.S. law. There's no U.S. law that gives us an answer yet. So let's look at what would happen in England and apply that law now in the United States. So basically the idea was if there was no United States law that dealt with the subject, a judge would apply English common law as part of the judge's decision. So that's why I have this term common law under court decisions. Because when judges decide court cases, those court cases are written up by a judge, and the law that is used to decide the case will be applied, and the judge has to say what laws are being used as part of the decision. So the idea of common law, the first meaning is the law that's applied from England in a court case if there's no United States law. So one of the ways I ask that question is the law of the United States derived from what country common law? Italy, France, Germany, or England? Answer? England, English common law. Now, this term common law has evolved. Okay? Judge-made law, which I have right here. Case law, precedence. So now let's fast forward. We're going from 1796 or whatever, late 1700s, to today. Now, we have lots of our own U.S. law. I mean, we have more law probably than we need. We could probably box it up and ship some back to England if we want. We have plenty of law. We have more law than people even know we even have. And so we don't really need, usually, to apply common law anymore, because we have our own law. So we now have another phrase that when we say common law, we're referring to, and that is case law. Right here, case law. And this is the body of law that is developed over time as the courts all throughout the United States, from the Supreme Court all the way down to lower level courts, even at the county or city level. Over time, court decisions have formed this gigantic body of law dealing with specific cases. And we're going to start with Supreme Court cases. The Supreme Court, when it issues a court decision, remember the role of the judicial branch is to interpret the law. So a judge in a court case is interpreting one of these sources of law, be it the Constitution or whatever. And when a judge interprets the law and applies it to a case, writes an opinion, the opinion is then published, and that becomes a body of law that we as lawyers and judges can research and apply. So for example, if I wanted to know the law of returning a borrowed item, I can go research court cases, and I'm looking for cases that are similar to the one that I have, and that we can use that as precedence. That is, we can rely upon that in our case. So if a judge decides a case involving a cow 10 years ago, I can now say, in that case, this was the outcome. I want to rely upon that same judge-made case and apply it to our case today. And over time, we have hundreds of thousands of court decisions that have developed this huge body of law that we can research and refer to. In the real world, we call that precedence. Now, the highest level of precedence, of course, is from what court? Federal. Which court in the federal system? The Supreme Court, correct. So the U.S. Supreme Court is the highest level court we have, and we're going to get into courts more next class. But the idea is, when the U.S. Supreme Court decides a case based upon the U.S. Constitution, that creates essentially an amendment to the Constitution, kind of. And that applies to all states and everybody all the way down the line as a matter of judge-made law. And I'll show you precisely how that works next class session when we run out of time. But the idea of judge-made law is the second component of this term common law. The first component is the law that carried over from England. The second component over time is these hundreds of thousands of court decisions that have now created precedents throughout the United States. So judges, the role of a judge, of course, the judicial branch, is to interpret the law and apply it to a particular case. And when that happens, the judge writes down the decision. That creates case law, otherwise known as judge-made law, otherwise known as common law. Now, judge-made law. You're like thinking in the back of your mind, wait a minute, it's not the job of a judge to make law, right? That's the legislature's job. Or perhaps the president through a treaty, etc. So a judge, under separation of powers again, when the judge decides a case, the judge is applying the law that was created from another source. So either the Constitution, a statute, an administrative rule, or perhaps interpreting a lower level court's decision. Now I'll get into that more next week. I'm getting way detailed today, I know that. Right now, I just want to start off with this basic idea that we have judge-made law, which we call common law, that started with English law that carried over and has developed now into, I like the term case law better than common law. Hundreds of thousands of cases over time that have been developed by court decisions. And again, I'm going to show you how that works more in detail in our next class session. And then finally, before we break for today, I just want to talk real quick about executive orders. And we also have judge-made law at the state level, and again, I'll get into that more next class session. Executive orders, number 6 on our list. So, an executive order, just real quickly, I'm not going to spend a lot of time on executive orders in this class. An executive order is an order that's issued by the chief executive or perhaps the head of a department about how the law is to be enforced or not enforced. So the president can issue an executive order on how a particular law will be enforced or not enforced at the federal level. At the state level, a governor can issue an executive order. Now here's the thing I want you to know about an executive order. An executive order cannot create new law, nor can it modify law. It's limited to how the law will be implemented or enforced or not enforced, but it can't write new law. And a court can review an executive order, including the president, or a governor, or a mayor, or whatever executive issued the order in their jurisdiction, to determine, is that executive order beyond the scope of the law that is being enforced? If so, that violates separation of powers, because that's an act of legislating. So the president can issue an executive order that can't change the legislative law. It can only be about how it's enforced. Now again, this is a very gray area. It's not as cut and dried as I'm saying, but the theoretical idea is the executive can't write law under separation of powers. The executive order cannot function as an alternative to legislating, just like an administrative rule cannot function as an alternative to legislating. That also violates separation of powers. Now, where that line ends and where it begins, that's a whole other thing. That's for courts to interpret. But we do see that happen. We see executive orders fairly commonly, both at the federal level and state levels. And again, we also see court decisions interpreting, is that executive order valid or is it legislative? Okay, we're about out of time, so we're at a break point. So next class session, we're going to pick up with judge-made law, and we're going to get a little bit more detail about how that works, and I'll show you precisely what I mean by that. So we will see you all next class.